The vital importance of the Second Amendment and the unconstitutionality of magazine capacity bans. The Second Amendment to the United States Constitution states, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Ratified in 1791 as part of the Bill of Rights, this provision is not a relic of the past, but a cornerstone of American liberty. It safeguards the individual right to self-defense, serves as a bulwark against tyranny, and ensures that citizens retain the practical means to protect themselves, their families, and their freedoms. Equally critical is recognizing that modern restrictions, such as bans on firearm magazines capable of holding more than 10 rounds, often mislabeled high capacity or large capacity, represent unconstitutional infringements. These bans fail the Supreme Court's established tests under District of Columbia v. Heller, 2008, McDonald v. City of Chicago, 2010, and especially New York State Rifle and Pistol Association v. Bruen, 2022. They lack any basis in the nation's historical tradition of firearm regulation and directly burden arms in common use. This essay examines the amendment's profound importance and demonstrates why magazine capacity restrictions cannot withstand constitutional scrutiny. The historical roots of the Second Amendment underscore its enduring significance. It draws from the English Bill of Rights of 1689, which affirmed the right of Protestants to have arms for defense as allowed by law, a response to monarchical attempts to disarm subjects and maintain standing armies. American colonists experienced similar abuses under British rule, where disarmament and quartering of troops fueled the revolution. The founding generation viewed an armed populace not merely as a militia tool, but as essential to preventing federal overreach. James Madison and others emphasized that the right belongs to the people, mirroring the individual liberties in the First and Fourth Amendments. As the Supreme Court later recognized, the prefatory clause about a well-regulated militia announces a purpose, but does not limit the operative right of individuals to keep and bear arms. In the founding era, firearms enabled both collective security and personal defense against criminals or oppressive government. The amendment gives teeth to other liberties. Without the ability to resist unlawful violence, declarations of rights become empty promises. CD 2. This was no abstract theory. Early Americans understood that a disarmed citizenry invites tyranny, as seen in the experiences leading to the Glorious Revolution and the American founding itself. The right is not limited to hunting or sport. It is fundamentally about preserving a free state through an armed populace capable of self-reliance. In contemporary America, the Second Amendment remains indispensable for practical self-defense and as a deterrent against crime and governmental excess. The Supreme Court in Heller affirmed the individual right to keep and bear arms for lawful purposes, particularly self-defense in the home, rejecting the notion that it applies only to militia service. 2.8. McDonald extended this protection against state infringement via the 14th Amendment. Today, law-abiding citizens rely on firearms far more often for defense than for offense, stopping threats where police cannot respond instantaneously. The amendment also functions as a structural check on power, reminding officials that the ultimate sovereignty rests with an armed people. Attempts to erode this right, whether through registration, confiscation, or capacity limits, erode the balance the founders deliberately created. Without it, vulnerable populations, women, the elderly, those in high-crime areas, lose an equalizer against stronger aggressors, and the security of a free state becomes dependent solely on government goodwill. The legal framework established by the Supreme Court leaves no room for sweeping magazine bans. In Heller, the court held that the Second Amendment protects arms in common use for lawful purposes, and that the right is not unlimited, but cannot extend to bans on weapons typically possessed by law-abiding citizens. Bruen clarified the test. To survive scrutiny, a firearm regulation must be consistent with the nation's historical tradition. First, courts examine whether the regulated item falls within the plain text of the amendment as an arm. If so, the government bears the burden of proving a historical analog from the founding era or Reconstruction period. DC 6D3E, magazine capacity restrictions fail both steps. Standard capacity magazines, often 15-30 rounds, depending on the firearm, are quintessential arms because they enable the core functionality of keeping and bearing arms. They allow the user to fire multiple rounds without reloading, directly facilitating self-defense. As the District of Columbia Court of Appeals held in a landmark March 2026 decision striking down DC's ban, magazines of all capacities are arms covered by the plain text of the Second Amendment because they facilitate armed self-defense. 7A2302-24719. These magazines number in the hundreds of millions nationwide and come standard with the most popular handguns and rifles sold today, accounting for roughly half of all magazines in civilian hands. They are not unusual or dangerous and unusual weapons. They are ubiquitous and overwhelmingly used lawfully. No historical tradition supports banning them. At the founding, there were no capacity restrictions on ammunition feeding devices. Muskets and early repeating arms evolved without legislative caps on rounds. The government cannot point to analogous regulations from 1791 or 1868 that blanket prohibited commonly owned magazine capacities. As the DC Court explained, there is no history or tradition of blanket bans on arms in such common use. A25-253. Post-Bruen, courts applying this test have increasingly recognized the flaw in older interest-balancing approaches that upheld bans based on modern policy preferences rather than text, history, and tradition. While some circuits and state courts, such as the Ninth and Seventh Circuits or Washington Supreme Court, have upheld similar restrictions by narrowly defining arms or stretching historical analogs, these decisions create a clear split. The recent DC ruling, issued by the district's highest court, directly contradicts them, holding that such bans are facially unconstitutional. A4A8F petitions are pending before the U.S. Supreme Court, e.g., Duncan v. Bonta and Gators Custom Guns v. Washington, and the DC decision only sharpens the conflict. Under Bruen's originalist framework, the correct conclusion is inescapable. Outright bans on magazines in common use violate the Second Amendment. They disarm law-abiding citizens in precisely the scenarios where rapid follow-up shots may be necessary for effective self-defense, while criminals ignore such laws. In conclusion, the Second Amendment is not a second-class right or a historical curiosity. It is essential to individual security, national freedom, and the constitutional design that places ultimate power in the hands of the people. Magazine capacity bans represent a modern legislative overreach with no foundation in America's history or tradition. They infringe on arms protected by the plain text of the Constitution and fail every prong of the Supreme Court's jurisprudence. As courts continue to apply Bruen faithfully, as the District of Columbia Court of Appeals did in March 2026, these restrictions will and should be invalidated. Preserving the Second Amendment intact is not merely about guns. It is about safeguarding the liberty that defines the American experiment. Any erosion of this right invites the very tyranny the founders sought to prevent.